Everyone, we are concluding our day with conversation about H-44. It's a bill that is currently living in judiciary and is moving. We have two representatives from the Judiciary Committee here, as well as Legislative Council. So, you know, not really, we really have not looked at the words on the page that in depth. So I guess probably the best order of operations is to start with the two members of the Judiciary Committee and then slide over to council for a more granular assessment. That sound okay to you guys?
Mm-hmm.
All right, that's a thumbs up from council.
Yeah.
Representatives, please join us.
I'm just doing the back part. I can do it if you guys don't.
Do you, are we just speaking on, Representative Goodnow from Brattleboro?
Borrow my straws.
Are we just talking about the very last section on the?
If that's the section that's relevant to us.
Maybe I'll go first.
Yeah, why don't you go first, council?
Sorry,
He didn't.
Good to see you.
Good to see you too, Mr. Chair. Do you want me to, well, if I were to get an invite, I could share it on my screen.
If you'd like to, yeah, that's fine, but we also have it here, so we can.
Yeah, and so for the record, Ben Novogrodsky from Office of Legislative Counsel. Really, the only portion in my assessment that really concerns this committee is Section 5, which is the creation of the Impaired Driving Processing Task Force. But to give you a general sense of what the bill does, so it makes, as the title indicates, miscellaneous amendments to the impaired driving laws. So that will range from technical corrections regarding, just gender neutral terminology, closing some loopholes on reporting requirements. So what occurs in a DUI prosecution is that there's also a parallel civil license suspension track. So there's the criminal prosecution, and then there's a civil case. A lot of times they proceed together. But the civil license aspect is handled once those decisions are made in court, is handled by the DMV. So the DMV is the one that actually suspends your license, but there are some reporting, for lack of a better term, loopholes in the law that means the DMV doesn't always get the information that they need from the courts in order to effectively suspend people's license. So in my former life as a criminal defense attorney, this is a personal anecdote, we would always advise our clients, your license is going to be suspended. However, our internal monologue is maybe it wouldn't happen because they wouldn't get the information to actually go forward with the suspension. So there are changes in this bill that closes that loophole. Also within that civil suspension process, in the criminal side of it, you can be criminally charged if you blow 0.08 or above, 0.02 if you are a juvenile, 0.04 if you're a commercial driver, or if you're under the influence, which is any slight impairment. However, the civil suspension statute, there was a slight, I guess, gap in the law that you could only get a civil license suspension if you blew above 0.08, not at or above, which is what the criminal violation is. So there are changes to align the two. So for both a civil suspension and a DUI prosecution, you will be liable if you blow 0.08 BAC or above, not just above. So like, for instance, with the civil suspension, it would be, you would have had to have technically blown a 0.081.
What an interesting legal wrinkle.
Right.
Yes. And so what page are we looking at right now? You said Section 5.
I'm just kind of giving you a general flavor of the bill right now. Putting you to sleep, which is fine. It's late on, the first session day of the week, right?
Yeah.
And then there's another portion of the bill that creates essentially a criminal refusal for not complying with a valid search warrant to obtain a blood sample. It's kind of a complicated procedure, but to try and summarize it, right now, if to obtain someone's blood, so there are three situations: either there's the breath test equipment isn't available, the person can't provide a sufficient blood breath sample, so maybe they're too impaired to actually do it, or they're suspected of being intoxicated by a drug other than alcohol. In those situations, you can obtain a blood test. However, you need to obtain a warrant prior to doing so. Right now, if the person were to not comply with the warrant, there's really no recourse other than charging that person with obstruction of justice. And the penalties associated with that are felonies. Most misdemeanors or most DUI charges are misdemeanors. So it really didn't have that nexus between the underlying offense of a DUI and then what would actually occur to try and enforce the process to get the information you needed. So what this does is create a criminal refusal charge for that, and should try and essentially keep that nexus of the underlying crime so that you're not being charged with a felony that has a lot more serious consequences and also doesn't have the rehabilitative requirements that are associated with the DUI laws. So it's trying to bring them closer together when it comes to sort of the crime and punishment fitting.
So Mango.
Thank you. If the situation is such that the individual is being charged with a DUI and something else that's a felony, changing this would not change the fact that they're also doing something that is bringing about a felony charge.
Correct. That's a separate analysis.
Thank you.
So what's really before this committee is in section 5 of the bill. And section 5 of the bill creates that task force. Why don't I have, Ian, can I bum the bill from you?
Absolutely.
Thank you.
Section 5 is the effective date. Is that
Or rather, the section 6 is the effective date. Section 5, so do you not have the strike all amendment?
we have we have the as introduced.
Okay, so the strike all amendment is what we're on draft 3.1 of the strike all amendment, not the as
Mind
introduced.
kicking that
I have a
everywhere.
3.1.
Yeah,
Cool.
I need to,
Can someone send a digital copy to our committee assistant?
I will do that as we
Thank you.
speak. So, to walk through that for the committee before you even have it. So what this does is that it creates a task force to essentially study the concept of implied consent. And so implied consent when it comes to DUI is sort of this bargain between the driver and the state that says basically, we're going to give you the privilege to drive on our roads, but it's under the agreement that if you do something that we suspect a DUI, you've given your consent for a breath test or blood test or saliva test if we meet certain procedural requirements. So that's kind of the general concept here. And what this does is to study that concept with the objective to recommend approaches that minimize the duration for which impaired driving suspects are held, and also to minimize the processing and paperwork that a police officer has to do as a result of that encounter. So that's sort of the dual goal here. Minimize the length of law enforcement encounters for suspects and to minimize the paperwork and processing that a law enforcement officer does as a result of those law enforcement encounters. So what this does, the way that this is achieved is that there's the membership, which is comprised of the chief judge of the Superior Court, the defender general or designee, the commissioner of public safety or designee, the commissioner of motor vehicles or designee, the executive director of the Department of State's Attorneys and Sheriffs or his designee, and a representative from the Vermont Police Association. So they're the people that are analyzing this work with the ultimate goal to issue a report of November 15th of this year with any legislative recommendations. But what they're really looking at are the constitutional and statutory requirements of implied consent, how those requirements affect the duration for which someone is held, various methods to minimize the statutory requirements so that they are still constitutional, but maybe we're minimizing some statutes that demand longer stops, more paperwork, and then essentially any other issues that come up during that study. So that's the goal of the task force, and really is what's in the purview of this committee.
Were you able to send that electronically to Autumn?
I have not yet.
Okay, so is it on your,
If-
judiciary's website?
It should be, but Autumn, if you send me a link right now, I can put it up to the screen and go. Oh, you did? Okay.
Is it posted, Autumn?
No, he's talking about a screen share.
So I'll do that and then subsequently I'll send it to Autumn so that you have it on your committee website.
Thank you, council.
You know, we adapt to survive, right? That's what we're trying to do right now.
And so, yeah, so the task force is the relevant component here. And it is, the information gathering and development body,
Essentially.
yes. Representative Nugent.
Just curious what prompted the creation of this task force.
I would defer to Representative Oliver on that question. But in the meantime, I am able to put this on the screen.
So I'm sorry, I just gotta take a minute. We're trying to dial in the AI on this like new camera, and we had these like with the gentleman over here now, it's like shifting the screen. It's like really
Jeez.
interesting. We're like workshopping new software and hardware. It's an interesting beta test.
It's so weird.
Yeah, it really is. It's a new thing. So
Well, glad that we can be guinea pigs. I suppose.
I was up for it when they told me about it. I was like, I'm down. I'll offer feedback.
So as you'll see here, section 5, subsection A is that creation section that kind of outlines the objective of the task force. And then you'll see here the membership are those 6 members there. And then the powers and duties of the task force under subsection C. 1, those constitutional and statutory requirements, so reviewing those, how they affect the duration of those law enforcement encounters, methods to minimize the statutory requirements so that they still are constitutional, and then anything else that the committee wants to explore that's relevant. It has the assistance of the Department of Public Safety to help with scheduling, writing, all that fun stuff. And then again, the report is due on November 15th of this year. The Commissioner of Public Safety calls the first meeting. The task force can select the chair at the first meeting. A majority is the quorum. And then the task force ceases to exist on February 1st of next year. And then compensation reimbursement. Basically, if you're not otherwise compensated through your job, then we'll reimburse you and compensate you for your attendance.
Okay.
Rep. Nugent, did you want an answer to your question?
Would love
Could we ask Rep. Oliver to come up and answer?
Happy to switch.
Thank you,
I
council.
brought a show and tell. Thanks, man.
Welcome. You want me to stop sharing my screen or should I keep it up there for now?
That's fine.
Yeah, I mean, I'm
Yeah,
indifferent.
sure. Let's let Rep. Nugent.
Thank you, Autumn.
Thank you.
So Thomas Oliver, House Judiciary, and I appear probably before you more as a practitioner of this than a representative, I guess. Having done many of these over many decades now, what I passed out was a processing form for DUI. Okay, now there's nothing else, anything like the processing of any RSD than a DUI is the most unique of them all. If you have your standard misdemeanor crime, you detect a crime, you take a statement, you write an affidavit. That's it. The documentation required upon contact with a DUI starts right there, page 1. And this is in the field. All this information you have to gather right here. Okay. It's kind of hard to do without this form. Unless you're really good at remembering it, you will forget something. Then you turn the page and you go into Miranda rights. You have to go through the Miranda rights and get an acknowledgement, yes or no, and then you go into an interview, depending on how they answer the Miranda. And lawyer contacts. They always want to talk to a lawyer. Most clients would want to talk to a lawyer before they're processed. Right. So you contact the lawyer, you sign and date all the times you attempted contact, who the lawyer was, so on and so forth. Go through the questions and then you arrive at a point of consent. Basically, this whole page is implied consent. Okay. Where you have to check off each individual box and explain to them what this is. Now, implied consent is pretty lengthy. It's pretty difficult to understand. Now, imagine being drunk and trying to. Allegedly drunk.
Yes.
Sorry.
The presumption of intoxication, yes.
Presumption.
That was just-
You know, if someone is minorly intoxicated or something, you might be able to get through this. Somebody who's moderately to severely intoxicated, getting through this is incredibly difficult. And very often, at the end, you have to contact a lawyer when you ask them if they want to give a sample of their breath as evidence. And you ask them if they want to talk to a lawyer, they'll always say, I already did. Did they tell you to do? Well, I don't know what I should do. So you call the lawyer again. And sometimes you make these calls 3 and 4 times before you get through this process. Now, mind you, this clock started the moment you pulled them over. So there's about a 2-hour window in which you want to get a good, reliable sample of someone's breath for evidence. And this is a misdemeanor if it's a first contact, no other DUIs. This is quite cumbersome. So the glitch, or not the glitch, the question is, implied consent assumes that you have a driver's license in the state of Vermont, that if you're driving on that driver's license, that you are giving consent for us to take a sample of your breath as evidence. Why are we asking again for your consent? You can waste an hour right here on implied consent. I'll pass that around. And that hour is very critical in the timing of when the stop occurred, when you have to have the sample of the breath. Right now, most DUIs take anywhere from 2 to 4 hours to process. 2 is very short. 4 hours is close to normal by the time you make the contact and release the person to someone or do whatever you have to do. So I'm trying to see if there was a way, not just implied consent, to take this burdensome or cumbersome pile of work and condense it into something more usable. What do we need to gather for evidence? What is being used on this page and what isn't being used in courts, for instance? Like the interview. Most of us, if Mr. Representative Goodnow might be able to say better, frequently when we process, we don't interview the person. The interview is fairly short, but we do read Miranda because we're asking things after we have obviously made a decision to arrest them. Any questions?
Representative Hoover.
There we go.
Why are incriminating questions on page 1 and Miranda's on
You haven't
page 2?
made your decision to process yet.
But you base that decision process on responses from the individual.
Do you have something to offer, counsel?
Yeah, and just to kind of provide some context, so there's that implied consent portion that Representative Oliver is talking about. So that is in statute. So in 23 VSO 1202 D6, it lists a series of information points that the law enforcement officer needs to state to the suspect. So this is a statutory requirement. So part of this task force would examine whether that statutory requirement is really necessary under the Constitution, when, as Representative Oliver has said, there's already implied consent in the possession of your license and then subsequent use of the roads. You've already consented to these breath tests, or if need be, blood or saliva tests.
When one attains said license, yes. You are
However-
making a sort of an agreement that you will subject yourself to these screenings.
However, sorry, Representative. What if the person has an out-of-state license? Is another question I would ask. What if somebody has an out-of-state license?
Yeah,
They are operating in Vermont. Well, yeah, no ignorance is excuse, but they would have to know the Vermont, you would think, have to know that Vermont has a consent law. Or you can look at what many other states do. They simply spell out, if you give a sample of your breath as evidence on a DUI one, this is what the punishment potentially, or the consequence would be, or exposure. If you refuse, this would be the exposure. Will you comply?
And
Counsel.
just on the point of the out-of-state license, so there are a lot of legal doctrines at play, but basically through the privileges and immunities clause, you have deemed to consent by using your out-of-state license and using Vermont's roads
Yeah,
to
correct.
comply with Vermont's
Yeah.
statutes. And then also, you're also presumed to know Vermont's laws.
Which is the case with like all laws, right?
Right.
You
Ignorance
can't
of
be
the
like,
law is
I didn't know
typically not
Title
right.
17, blah, 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 didn't, yeah. You can't
Typically,
play like,
ignorance of the law is not an excuse.
So my question was about other states. How many other states or?
I've only looked at a couple, but very short.
And they use implied consent.
Well, it wasn't implied consent necessarily, it was just, will you give a sample, yes or no? And if yes, this was your exposure, if no, this was your. About that long.
here's $1 million question, what's the committee vote on the bill?
Was it?
What was the committee vote?
Yeah, it went out all 11 of them.
Okay.
Yeah. It was an
Just get a feel for
opportunity
the
to,
room.
I looked at it as an opportunity to bring something up that I think that needs to be addressed for a very long time. I can't take a statement from somebody when they're.
Representative, why don't you grab a chair and do it, do well?
What's that?
You're just raising your hand, you're
Yeah.
here, why don't you
No,
just
wait,
jump up?
Yeah,
and do it? No, I'm like asking you to, it'll make it easier. Yeah, grab a chair, yeah.
I can't take a statement from somebody that's intoxicated as a witness. But yet we've stopped somebody because they're impaired. Their judgment is impaired. And here I am asking for all this information when they are impaired. How do I know they're making the right decision? Well, they did talk to their lawyer, but they don't always.
And did you have anything to offer on that?
I just wanted to, I think, agree with all the points that were made, and just to offer another perspective that there's a balancing act that needs to be sort of struck here when you're trying to protect someone's constitutional rights, but also ensure that the process is smooth and efficient. And I think Rep. Oliver has identified an area where that may be out of whack. And what the problem from a defense attorney's practitioner's perspective is that you can really confuse somebody and impact their ability to exercise their constitutional rights from the other side, where they don't really know what's going on because it's so convolutedly complicated. So I think that it would be very helpful to have some individuals who are very versed in this law take a look at this and see whether it makes sense how it's happening right now, or if there can be some tweaks and changes to the system so that it's operating more efficiently and also protecting the rights of defendants.
Very well said.
And also to piggyback off of Rep. Goodnow's for defense attorney analogy, there's also the concept too, that the longer that a suspect is held, the more evidence that can be gathered against them, not only just confusion on their part because of the laws, but the longer an encounter, the more chance there is to investigate and gather evidence, in addition to the more paperwork that may have to be done by the police officer. And then secondly, to answer Rep. Pango, your question about other states, that's part of why this task force is being created.
To study that.
They could examine other states as well in this analysis.
Thank you.
I think my last question just for myself is you got Commissioner of DPS or designee, they're on board with taking on this task.
That I don't know.
Did you have them in for testimony?
Well, there was
to
some
talk about
conversation
this?
about it, for folks that weren't on payroll, what would it cost? But most of these folks would be working, I think, during.
No, I'm speaking
Partner.
specifically to, like, it says
Oh.
Commissioner of the Department of
I haven't
Public Safety. Yeah,
Is it and designee?
Yes.
or it's an or.
So, yeah, so it could be a designee.
No, that's fine, but they are like willing to take on this job. To like run this committee. This task force.
I'm not aware of any testimony one way or the other.
Okay.
I think they were indifferent.
I don't know.
We'd have to go back and check.
Yeah.
If you could ask Representative Lalonde that question for me, I would greatly appreciate, we appreciated a text message will do.
Yes, sir.
Anytime that we have an agency or department take on the responsibility of running a task force, I like to get their thoughts on
Absolutely.
The question is noted.
it. Thank you. And when is this on the floor?
Well, I think I heard today it went to appropriations.
Okay, so there's time. All right, cool.
It was, it was on notice today to go on the floor tomorrow, but I think there were some new committee assignments that might.
Gotcha, because my last update was for tomorrow, so if it's going to appropriations, that gives us a little bit more time to suss out that question. Representative Wood,
Just a process question, do we need to do a straw poll on
This would be a
or-
straw. Yeah, this is not a formal vote.
Yeah.
We're not taking possession of it. Anything else for these gentlemen? No? All right, no, thank you very much. Yeah, this is a great also workshop for new members about purpose committee jurisdiction and drive-bys, so thank you for the exercise.
Drive by.
Yeah.
Drive through is the more,
Oh, is that a more drive through?
Yeah. And if any of
There's
the
like
new,
3 jokes I'm gonna crack right there.
if any of the new members have questions about this process, I'm happy to answer them.
Thank
Okay,
you very
thank you.
much.
Thank you. Yep.
It's helpful. Thank you.
Thank you.
Thank you.
Thank you. I'm like Trump.
Oh, well,
Like
I don't
Trump.
know.
Yeah.